Hi, I'm Mark Mifflin. I'm a member of the Illinois Defense Council Legislative Committee, and I'm here to give you an update on the status of the legislation which was considered and passed. Most of them have passed and been signed by the governor in the spring session of 2019. It's 101st General Assembly. And then the veto session will come up in October and November of this year, and then the second year of the 101st session of the General Assembly will begin in January. So that's where we are, but there are 6 or 7 bills that I wanted to draw your attention to that have become law, and 1 or 2 are pending, so that you can be aware of these changes. All of the bills that we followed, and there are many, many more that we have followed during the spring session, are listed on the advocacy section of the Illinois Defense Council website. So you can view all of the different legislation that we've monitored there. And in fact, there are new bills being filed now that will be considered in the veto session or in the spring session that you can see what's pending and what's going to come up in the future here. The first bill I wanted to point out to you is House Bill 2233. That is now Public Act 101-0184. That's a bill dealing with special interrogatories. I hope you received an email from Sandra Wolf at the IDC on this bill earlier in the session. Instead of having the special interrogatories be mandatory and binding, this bill makes it discretionary to the judge, and the judge directs the consequences of the any special interrogatory finding to the jury. And the lawyers are free to argue the special interrogatory effect to the jury in their closing argument. So it really does emasculate the whole idea, the whole purpose of special interrogatories, and it mixes the findings of fact and application of the law functions of the court and the jury, which we were all taught in law school. This is designed to remove the possibility that special interrogatories will take away verdicts from the plaintiff. And it was a trial lawyer's bill, ITLA bill. And the governor has signed that. It is a public act. The next bill is House Bill 2472. It is now Public Act 101-0025. That removes the administrative authorization defense to the Consumer Fraud and Deceptive Business Practices Act. And it also allows causes of action for products liability under that act, the Consumer Fraud and Deceptive Business Practices Act, which is significant because in those cases attorney's fees are available. So in products cases filed under that act, attorney's fees will become available. This is another trial lawyer's initiative that the governor has signed. The third one is Senate Bill 1596. That's Public Act 101-0006. This is one that was taken care of early on in the legislative session. It's another trial lawyer initiative, and it substantially limits the effect of the statute of repose in workers' comp and occupational disease cases. The bill holds that an action can be filed in circuit court, so it takes it out of the work comp or occupational diseases arena, even though it is against the employer. It can be filed in circuit court if a latent disease does not become known until after the 25-year statute of limitations has run in the Comp Act and the Occupational Diseases Act. So this keeps that cause of action alive. There's no limitation on when it may be filed. It's our hope that it will be of limited effect because hopefully most of those cases under the asbestosis and mesothelioma have been determined, but it could come up in the future in cases like the Roundup cases or any other types of latent diseases which come up. So that's a significant bill which really for the first time opens up the court system to work comp and occupational disease cases where there have been latent diseases discovered. The next bill is Senate Bill 75. This is a very significant bill that has not gotten much publicity. It's Public Act 101-0221. This deals with workplace transparency, and it substantially expands the employee rights in the workplace at the employer's expense. There's been some confusion about this bill. It came from Senate Bill 75, but there were some articles written detailing the provisions of Senate Bill 1829 which was the original bill filed with the Transparency Act. So don't get fooled into thinking that that's the law. It's Senate Bill 75 is what became the Public Act 0221. There is an article on the IDC website on this new bill written by Kimberly Ross, which you can find, like I said, on the website. I can't detail all the changes for you here. It does make changes in the Human Rights Act, the Victims Economic Security and Safety Act, the Illinois Equal Pay Act, and the Hotel and Casino Employee Safety Act. So it is very broad-ranging, and it does give the employees substantially more rights. So take a look at that if you represent employers, and what they have to do to satisfy the new law. Another bill that was just signed by the governor, it's Senate Bill 1378, and that bill provides that you cannot exclude jurors based upon sexual orientation. So that's a new law that will take effect also. That's Public Act 101-0327. And by the way, I'm giving this, I'm sitting here talking to you on August 27th of 2019. The bills all passed by June 1st, and then the governor, they were 30 days to get to the governor from the legislature and 60 days for the governor to act upon them. So we're reaching the deadline right about now. Our bill, the next bill I want to mention to you is not law, did not pass. It's our bill that the Illinois Defense Council has put forward through Republican leader Brady in the Senate. That deals with joint and several liability, and it includes a couple different provisions. Ones that would not allow you to tell the jury about the effect of the 50% for the plaintiff, because you can't do that on the 26% joint and several liability for the defendant. So it would level the playing field in that respect. It would also require that all tortfeasors be placed on the verdict form for the defendants like they are for the plaintiff, which again is a level the playing field issue. That bill was unfortunately stopped by the trial lawyers in the General Assembly. It is still pending. It will be pending next year, and we're hopeful to get a hearing on that bill next year and try to push it through. We don't expect to have much success with that because the Democrats do control the House and the Senate, and Governor Pritzker is a Democrat. So they have been, as you can tell from the bills I just read through, been running roughshod over the wishes of the Defense Council, the business community, and the insurance industry on the issues where they wanted to change. We do expect that there will be new legislation next year, perhaps dealing with asbestos bills. There was an asbestos bill this year put forth by the insurance industry that did not go anywhere, and it riled the trial lawyers. So that type of bill may come forward. And of course, we have the tax bill, the Tax on Professional Services bill, which is also going to be filed, which will come up maybe even in the veto session, but certainly in the spring, if not. So we'll watch that bill too and keep you advised on that bill. So that's basically a summary of where we are right now. We will continue to stay involved for the Illinois Defense Council. We'll be there during the veto session. We'll be there especially during the spring session. And the website will be updated regularly with the new bills that are filed and the activity on those bills and the status of all those bills throughout the spring session. And from time to time, after some of the deadlines in the legislature, which have not been set yet, but we will provide more videos to keep you up to date. So take a look at the website if you want any information about these bills or the public acts now that have been signed by the governor, and we'll keep you up to date. Thank you very much. I wanted you to also be aware, I'm sorry I forgot to mention this, this is not a bill that deals with the substance of the law or the procedures of the law like we talked about, but there are two bills, that one of which is a public act now signed by the governor, dealing with the drawing of judicial subcircuits in the courts. The first bill, House Bill 2625, deals with redrawing the judicial boundaries after each federal census, beginning with the 2020 census. It's limited to a certain number of circuits. It's Cook County and the 12th and the 16th and the 17th and the 19th and the 22nd Circuit, I think are the circuits that are covered now in that bill. So they will be redrawn after the 2020 census. there's another bill, House Bill 97, which remains pending in the General Assembly, and that deals with Champaign County, and it would make Champaign County its own circuit, and the surrounding counties, which are now part of the 24th or the 6th Circuit with Champaign County, would become the 24th Circuit. So the idea behind this, I think, is that there would become more judges in Champaign County because of the population and less judges in the surrounding area. And I think, of course, if that passes, then we can expect this type of activity in some of the other circuits around, maybe those that are already being redrawn, and maybe the creation of some additional circuits like they're doing like they want to do in Champaign, in some of the other areas where there's an urban center that it feels like it's underrepresented. So I'm sorry I didn't say that before, but those are the two bills that are out there dealing with that, and we can expect more activity in that area too. Thank you very much.